Everybody's got their papers and pens ready. All right. Our next case is Gary Dean Janssen and Larry Dale Janssen versus Security National Bank as executive of state of Janssen. It's my understanding Mr. Wonio is going to argue for the appellant. Is that correct?
That's correct, Your Honor.
And it's also my understanding that Mr. Lessmann and Mr. Deinert are going to both argue? Okay. You are the keepers of your own clock. So typically the first person gets a lot of time, in my opinion. But anyway, that's your problem, not mine, okay? All right. All right. As long as we're all on the same page, that you're the keeper of the time. Okay. We will begin with appellant, Mr. Wonio.
May it please the court, counsel. Thank you for the opportunity to appear before this court. This case is essentially a will contest, to simplify it, and is concern satisfaction of the rules and statutes governing notice to litigants. Litigation lawsuits have two primary goals. One is to end the controversy between the litigants, and the second is to end it justly. The first being just as important as the second. In this case, Mr. Smith and I had the opportunity to try it the second time the case was previously tried. And I want to talk just to run through the timeline because I think it's important from a notice perspective. The petition in this case was filed way back.
I kind of know the time frame pretty well. The briefs are good. Here's what I want to get at. You're saying it's a notice issue. The statute says all known interested parties shall be joined. Are you saying joined means just notice? Does it mean joined throughout the proceeding, joined at the beginning? That's the language we have to interpret, right?
I think that's fair. I do not read joined the same way that our district court judge did. The district court judge, I believe, phrased it as ongoing. I don't believe that's correct. I think the statutes and the rules contemplate notice and an opportunity to be heard. And that's what we have. What notice does is notice confers the jurisdiction of the court. And the jurisdiction of the court permits it the panoply of options to adjudicate a party's interest. That's precisely what happened in this case. So it doesn't talk about rejoinder or bringing back parties. The court's obligation is to make sure certain and specific parties do receive that notice under the rules of civil procedure, not an ongoing mandate to remain part of a litigation. Once you receive your adjudication, in this case, it was the dismissal with prejudice. That is a judgment. That's an adjudication. Once your rights have been adjudicated, that's it. I don't see and I don't read the rules or the statutes requiring some ongoing participation, named party in a litigation. And I don't think that would be the result this court would want either. If, to pick on you, Justice Mansfield, if I'm Justice Mansfield and I've been sued by Donald Trump in some sort of a lawsuit here in Iowa, and maybe I just don't want my name in the paper every single day. Once you consent to that adjudication, that should be it. You shouldn't be forced to be brought back into a will contest or other case where indispensable parties are contemplated. And I think the district court got that wrong. And the reason I think part of the reason he got that wrong was because he confused subject matter jurisdiction versus the court's authority to hear a case. And that confusion led astray his analysis. But probably even more importantly, the mistake was made when the district court judge totally put the blinders on to the concept of notice that I talked about. All of the other cases that have been cited against us or that were cited by the judge, other than the Florida phosphate case, which I'll talk about, all of them contemplated a notice and an opportunity to be heard. And I think you can also read two subsections later in the probate code, 633.312 is the the notice section we're talking about specifically, but if you look at 633-314, there's an adjudication of a non-appearing party expressly contemplated in the statute. So I don't think, and the suggestion that you have to have your name on a lawsuit is what's required by the statute and the rules. I don't agree with that.
What is the significance of that they consented to dismissal of these parties shortly before trial?
Good question, because I think it's got a lot of different arcing considerations, and one is what I was just talking about, and that is subject matter jurisdiction versus the court's authority to hear a case. Subject matter jurisdiction is not waivable. You could not consent to subject matter jurisdiction. That's not what we're talking about here. What we're talking about is a statute and a rule of civil procedure. Statutes and rules, while courts often use jurisdiction, subject matter jurisdiction, and authority to hear the case interchangeably, they are different. Authority to hear a case, rules and statutes cannot define or outline subject matter jurisdiction. They can set parameters on or limitations on a court's authority to hear a case. That's exactly the rule and statute we're dealing with in this case. But it does not impact subject matter jurisdiction. And to your greater point, the distinction is, and I know we cited some of the cases in our brief, the distinction is authority to hear a case can be waived. And that's expressly in the case law, and that's exactly what happened here. And to take it further, again, to point out, that was an adjudication. Right there, the court has the authority via the notice, has jurisdiction via the notice. That jurisdiction is exercised in a variety of different ways throughout cases. Summary judgment, ironically, this party sought summary judgment. At the first trial, this party sought a directed verdict. To be fully dismissed from the case was the relief that was sought in both of those.
It ultimately ended up being with prejudice, is that right?
And that's important, I think, in this case, and the ALR lays out affirmatively that's a judgment. And again, notice, which is what our rules require, and the opportunity to be heard, and that's via service of an original notice in this case, confers the jurisdiction of the court. The jurisdiction of the court opens up those avenues to adjudicate, the authority to adjudicate a person's or a party's rights. And that's exactly what happened here.
District Court can apply kind of a waiver analysis to whether or not Deborah actually, when she consented, whether that was a knowing and voluntary waiver, and distinguish between consenting to dismissal of the specific claims against her versus dismissal as a party. Can you address that, please?
I will. A couple of different things, and I think an argument could be made once the adjudication happened. She wasn't even an indispensable party at that point. But I think to the greater question is, what does a party get? You get notice. You get an opportunity to be heard. As some of the case law points out, you get the right to have a counsel assert arguments and speak on your behalf if you so choose. In this case, the most important and specific thing to answer your question is the motion for directed verdict ruling. The district court expressly conveyed to these parties they may have divergent interests in this case. That was in the footnote, and the district court sidestepped.
Talking about the two defendants.
That is correct. Yeah, and not the executor, but had the same lawyer. The court notified, expressly indicated to them, you may have divergent interests. This lawsuit had been going on for, at that point, several years. It had been tried once. There was no assertion of any partial validity argument or any other rights by way of a counterclaim or otherwise from her. So I disagree with the district court in that kind of a roundabout waiver argument saying it wasn't fair to her. I totally disagree. Had every opportunity for years, and I think it speaks volumes. The district court did not address the footnote that we identified in our materials because the court told them, hey, you guys may have divergent interests. there may, and I believe the court used the word conflict of interest. And not only are they on notice because they've been served with the lawsuit and then they make the decisions. It's not the court's job to babysit parties or otherwise assert arguments.
Argument that by simply being served with notice and providing an opportunity to respond, that satisfies the indispensable party issue? But the language in 1.234 says that the party's absence will prevent the court from rendering any judgment, which that implies to me that a judgment is the end of the game. And it says an absence will prevent us from getting to the end of the game. So doesn't that kind of Justice Mansfield's question, at what point can they just have to get in and then they can jump right out, or do they have to stay in? Doesn't that imply they need to stay in till the judgment?
I disagree with that. I think, and I did disagree with the district court's fluid use of that word absence, because again, I'll point to 633-314. That contemplates a party that's been served, had their rights adjudicated against them, and they never appeared. Well, is that party absent?
Lack of appearance, I mean, couldn't they be viewed differently? Appearance because of notice is one thing, but absence implies that they're completely removed from the case, whether they ever filed an appearance or not. Wouldn't that be different?
I don't see it as different in this setting. I don't think absence says you've got to stay on in some fashion throughout. And I do wholeheartedly think you get original notice and an opportunity to be heard. And I think the case law is pretty clear on that. I think it was the Davis case that was decided after the Ditch v. Hess case that said that. And all of the cases that we've cited, the main theme is you get notice and an opportunity to be heard. It's not some ongoing duty for the court to bring you back in or make sure you somehow participate in some fashion. That I don't read absence to mean an ongoing duty. And I disagree with the court in that fashion. I don't think that's a position this court wants to take. If, let's say the court granted her motion for summary judgment and dismissed her from the case as a party, would we then be, if we went to verdict and didn't like the verdict we got, would we then be within our rights to say, wait a minute, you have to bring them back in? I don't think that's the result that we want to have from this case. I don't think there's any ongoing duty, and there's no re-bring them back in. Specifically, the statute and the rule talks about if they're not involved, what do you get? You get notice. That's it.
Concerned about sandbagging if somebody allows it or doesn't object to the dismissal of a party, then doesn't like the outcome of the trial, and then says, I want a do-over because we were missing an indispensable party?
I'm trying to think of the exact case, but the case, and maybe it was Ditch, where the court talked about, well, they laid in the weeds and knew about this, but then didn't raise it until later. The key distinction in that is the indispensable party never received notice. And to me, that's logical. If you're going to resolve a land dispute and you don't have one of the owners of the property involved, never gets notice of anything going on to adjudicate their rights, that to me has an alarming effect. The difference being, if you are eyes wide open, you've received your notice. You've received your opportunity to be heard. You can't then later be heard to complain that some mechanical application of the statute or these rules was unwilling or unknowing. And yeah, I think if the court would have dismissed her on summary judgment and they come back, sure, I think sandbagging would be a considerable issue for the court to deal with. Not to mention a fluid and floating obligation of the court, because I think the district court misunderstood its obligation. And the obligation is to serve notice on parties. That's it. There's no obligation to bring them back in or allow certain parties to be dismissed or not. I did say I wanted to touch on the Florida phosphate case. That was the lone case where there was suggestion that a indispensable party received notice, but then it was appropriate to bring them back in. the distinctions are startling. In the Florida phosphate case, the two defendants that received notice joined with some other defendants in an answer. The procedural chronology of that case is very strange. The court recounts the files were lost for a great amount of time. The pleadings were very unclear. But very importantly, the dismissal that was filed of those defendants that had joined with other defendants, the court found was improper procedurally and should never have been received by the court. So that distinction is very important, the factual distinction of them being joint parties with other defendants. And that's literally the only case where notice was provided that the court relied on. If there are no other questions, my time's done. Thank you.
And your name? Thank you.
May it please the court, counsel. I'm Ryland, Deinert of the Class Law Firm in Sioux City, and I had the pleasure of attending both of these trials in this matter, the first one being in October of 19. And then COVID came along and it delayed the second trial. And then I had my second child, which delayed the second trial again, and we tried this case again in June of 2019. With that, and from the entire time the petition was filed in 2018, both Deborah Schultz and Cheryl Collins were accused of tortious interference of their father's will. They were both accused of taking advantage of their father when he lacked testamentary capacity, and they're also accused of unduly influencing them. The issue of partial invalidity, which was argued in the first argument, was not an issue in the first trial because Deb Schultz was being accused of the torts. It was either she unduly influenced her father, or she took advantage of his testamentary capacity, or she tortiously interfered with the will. Partial invalidity wouldn't have been brought up. It wasn't until 18 hours before the start of the second trial that Gary and Larry Janssen, although their brothers Jeff and Dean had dismissed themselves out of this case 18 days before the second trial, is when Gary and Larry Janssen at approximately 12:03, I can't remember the timestamp, decided to dismiss Ms. Schultz.
Stuff happens on the courthouse steps all the time, and I think as lawyers we're used to that. It's motivating. You get close to go time, and people make decisions that are significant. So I don't think that's so surprising. Whether we look at 633 or the Rule of Civil Procedure, here's my question. I've got sibs. If my brother says, I'm going to sue our sister, and I say, no, I'm not, I want no part of it. So obviously I'm not going to be a plaintiff in that case. And let's say it's a will contest. So then, according to the rules, I got to get drug in. I got to at least be given notice if I'm going to be the other side. And let's say I say, no, I also don't want to go against him either. I want nothing to do with it other than getting notice. Of course, I understand that. In what universe must I stay in a lawsuit if I choose even, and they're represented, I understand, but help me understand how we can force someone to stay in litigation if they truly have no dog in either fight and just want out.
The statute, 633.3112, I respectfully disagree, does not require just notice. It requires parties to be brought in as defendants.
In the game for a couple of years, didn't they?
Chief Justice?
They had lawyers, right?
They did.
Be joined sounds like something you do at a specific point in time. Shall be joined. They were joined, and then they got out.
Doesn't indicate and doesn't state that you then can be dismissed. And in this
Partial invalidity thing. The problem with that, or partial validity, is as I read this will, the provisions, it's the same provisions that benefit Deborah and Cheryl, Deborah and Cheryl, Deborah and Cheryl. So how would you partially, validate? It seems to me it wouldn't work under our cases. I'm sorry.
Justice Mansfield, yes, it would be tough in this case, and that's because you're right. The provision links Cheryl and Deb together. That's right.
Instructions, I mean, this happened at the last minute. There weren't instructions submitted to on a partial validity or partial invalidity theory prior to trial, were there? Okay.
Submitted proposed jury instructions. Deborah was a party being accused of tortious interference and the other torts.
If the theory is that if she wasn't guilty of the tortious interference or the undue influence or whatever, then she could take under the will could be validated as to her, and that would have been a valid theory whether she's in the case or not, right?
Strategic purposes, though, they were aligned together. The sisters both believe they didn't do that, and so they didn't want to divide each other, and that was their decision.
If we find that Deborah's rights under 633.312 were waivable, does your client lose?
Yes, they could. And I believe they're not waivable because the issue with indispensable parties, as both the Ditch and the Rice case indicate, is it can be brought up even on an appeal. There's no case on point in regards to the issue of waivability in this case.
Of the point that Justice Waterman was getting to about sandbagging, it strikes me here that no one objected to this dismissal, and then the jury verdict comes, and then this argument is then made.
There's a small little nuance to that, Justice McDermott. The first is Security National Bank had made a motion for sanctions at the pretrial hearing that went over the time the veneer was going to join in, asking for a continuance of this trial with everything changing. So there was somewhat of an objection. But at the end of the day, yes, Deborah said, yes, dismiss me because she had these tort claims against her seeking monetary damages. What happened then, though, is, and I think there's confusion both on Gary and Larry Janssen's side, is if you see in the post-trial motions, they argued to Judge Hinman that they didn't dismiss Deborah on her interested party status. They dismissed her on the tort claims. And Judge Hyman said, no, that's not true. Your dismissal was with prejudice. You asked that the sequestration order apply, so Deborah wasn't able to attend trial until she testified and then stay thereafter. And they filed a motion in limine the evening before trial saying she couldn't mention that she was a former party of the lawsuit. In regard to this waiver issue, and bouncing back, Justice McDermott, the reason why we believe it's not waivable is you have to have an intentional and knowing waiver of your rights. And with the abuse of discretion standard, which is a high standard for appellants, there has to be look at the totality of the facts, what happened, the logical deduction of the trial court. And everything was happening so fast the morning of trial, including we didn't even get to finish the arguments on these new motions in this dismissal because the jury was coming in. And at the time, thought was, well, yeah, this tort claim's not against us anymore. Let's dismiss it out.
It's when somebody's pro se and doesn't have the legal advice of counsel. But in this case, how do you know they didn't spend all night the night before pulling an all-nighter between attorney and client talking about the pros and cons of making this really radical decision on the courthouse steps? How do you know?
We'll never obviously know unless we depose him. But if you looked at the exhibit list,
Privileged anyway, what I'm talking about?
but if you look at the exhibit list submitted by the appellants, they didn't include any of the medical records, which would have been needed if the lack of testamentary capacity claim was going to move forward. And so at least as of 2 weeks ago, there's strong evidence that they knew they were dismissing the lack of testamentary capacity claim. I would surmise that they also knew they were dismissing Deborah Schultz at the same time if they were not even submitting exhibits for medical records.
Back to the indispensable party rule, how is this dismissal different than any other pretrial dismissal on motion? So for example, if it was a summary judgment granted in favor of a party or a motion to dismiss in favor of a party, why is that different than this case?
Your Honor, because with summary judgment, and Deborah Schultz did file motions for summary judgment to get the tort claims dismissed as against her. However, as Judge Hyman pointed out, she still should have been in as an interested party. She had a right to work with counsel during trial instead of being sequestered. She had a right to listen to witnesses and help respond. And she had a right to prepare because now there's a backdoor default judgment entered against her because Deb Schultz takes differently under the 2018 will that was in dispute in this case as opposed to the 2014 will of Richard Janssen.
What do we do with the fact that none of these arguments were made in the district court?
Which argument?
sequestering her and things of that sort.
Objection to her arguing that she was a formal party or not. That was definitely objected to.
But Deborah did not file a motion to intervene or otherwise seek to, I mean, you said she made a tactical decision to join forces with Cheryl. And so she didn't make a motion to intervene after she'd been dismissed so that she could remain at least a party. Is that correct?
She wasn't even dismissed until literally 2 minutes before we started with jury selection. I believe it was 5 days.
All that time that she could have thought about it and said, oh, no, wait, I want back in, and could have filed something.
5 days, Justice May.
That I've never seen a proceeding where a person has the claims against them dismissed, they are dismissed without prejudice, but yet they're still participating in the trial. I have not seen that.
For your
Why do we think that would be a good solution to this problem if nobody's ever seen it?
a will contest is a different animal. There's specific statutes, 633.312, as required in.
Never seen it in a will contest, have you? Where a party's been dismissed, but they're allowed to participate during trial and make objections and motions?
I have a trial in Ida County on a will contest where I represented 5 siblings, and it wasn't known until the day of trial who the actual tort claims were against. And so in that case, 2 of the siblings didn't have the tort claims brought against them, and they did participate, and they were able to sit and watch the entire trial as well as testify. And so I have seen it in the will contest case.
Their own witnesses?
I represented them actually as interested parties, and yeah, we consulted with them. We had attorney-client privilege. They testified themselves. They weren't sequestered. And Judge,
With prejudice before the trial started.
wasn't a formal pleading of it. It was just the plaintiff at that point.
Situation. I mean, legally, this person has been dismissed from the case versus somebody who's named but may not have specific claims against them. That seems very different to me.
Why the will contest situation is different, and there's different rules. And we have the rule on interested parties, because if you're not being accused of the tort, you may still have different rights or benefits or responsibilities under the will being contested or the prior will that may get reinstated if the newest will.
Our law generally really likes settlements. And would it not be appropriate for a party like Deb to have reached a settlement with the plaintiffs and then be out of it before the trial?
Well, settlement discussions never really boiled up at right before trial or not, so I suppose there could be a settlement, but she would still be an interested party no matter what. If the settlement waives certain rights, I guess, was that what you're getting at?
Let's say that they just said, here's $10 million. I want you to not show up for trial. I want you to walk away from this will. That seems like a pretty good resolution, and she'd have nothing to complain about.
That wasn't the case in this situation. She wasn't offered $10 million, Justice May.
The settlement part of a case, why someone, I mean, I think it's not unusual what he's talking about. Maybe the dollar sign is a little crazy wild, but that fact pattern is very common, and we don't delve into, would we have to delve into each and every case as to why did you dismiss last minute? Like I said before, courthouse step negotiations, I think, are some of the best negotiated cases I ever had as a lawyer, were ones on the heels of a trial. That's not so weird, is it? And it's private.
Negotiation, Your Honor.
Say so, but there's no evidence that it wasn't. There's no, you're saying that today, but there's nothing on the record to say there was absolutely nothing out there.
You're talking about settlement negotiations, right.
Record.
Rules of evidence to exclude them as well. With that, I went over my time. If there's any other questions, I'll let Mr.
6. Oh, that's right, sorry. So sorry, sir, come on up.
answer, otherwise I'll let Mr. Lessmann take the last minute and a half.
Sorry about that.
All right, Your Honor. My name is Colby Lessmann. I'm the attorney for Security National Bank, the executor in this matter. I'll jump right in. The biggest question is the statute and how it applies, I think, from your question. Can you be forcibly brought in? You don't want to be on either side. In the will contest context, yes. You have to either be a plaintiff or defendant. Just because you're a defendant doesn't mean the jury's going to award damages against you. Look at our position. We started the trial and the jury closing as an opening saying, yes, we're a defendant because we're defending the will. We're not here for damages or liability, anything like that.
Short time. I just want to ask you, so I totally agree you have to be joined. What's the best authority that says that you have to remain joined, that you, if you're one of those parties that just don't want to have anything to do with it, that you cannot be dismissed?
Well, first, there's no authority that says at all supports what they're arguing, that you just have to be given a notice and you never have to show up. I think yeah.
Absolutely was joined.
The definition of interested party and indispensable party. I mean, you have a right in how this case comes out as to whether your rights are going to be diminished under a will or not. And
You choose to be dismissed from that. Why should the court not recognize your choice to an agreement to be dismissed?
that consent and waiver issue has to be a known and voluntary dismissal or consent to that dismissal. And I think if you look at our briefs in the context of how things happened, we're not just talking about a dismissal of Deb at this time. We were also talking about the midnight dismissal of testamentary capacity, which had been an issue for 4 years, had been the subject of pretrial conferences and hearings and exhibits for 2 weeks. And suddenly at 12:54 in the afternoon before the jury starts, you're revamping your jury instructions as the judge and the attorneys. You're revamping your opening, your closing, your witnesses, your exhibits, everything. And I think overall, this will contest was filed 4 years prior. And nobody's really going to look at 633-312 in the middle of trial because the lawsuit's been on file. And I think everybody, the judge, the plaintiff's counsel, I don't think anybody ever really thought about the whole interested party context of will contest. And that goes into what your question was, Your Honor, that I've been involved in a lot of will contests. Nobody's ever been dismissed and not there. All the interested parties have always been there because that's what the statute says. So am I out of time?
Growing now. The time is growing.
10 minutes? Okay.
I still got more time. Yeah.
Thank you. Appreciate the time.
Get a different clock. Mr. Wonio.
Thank you, Your Honor. I have just a few points to make, and then we'll certainly answer any questions. Let me start where Mr. Lessmann left off. I hear the argument from them today that they were so surprised. Well, they asked for summary adjudication years in advance of this. They asked for directed verdict. The footnote in the ruling on the directed verdict from the first trial clearly outlined this. I don't think it's fair for them to now stand up and say it was a surprise. And I think to Justice Christensen's point, these are not people without experienced legal counsel for all those years. Presumably when they filed the motion for summary judgment and specifically asked to be dismissed, they would have thought of the ramifications of that.
Just a question about, it feels like this is a totally technical issue in the sense that if Deborah had remained a party and had just filed a document that said, I'm going to remain a party, but I consent to whatever happens. I'd like to not participate in anything. And then her name would just stay on the pleadings. I'm not saying that would have been a better result, but I don't see how that is different than what happened here. And so I don't see what effect they're gaining by keeping her in as a party.
I don't disagree with that at all. It is a form over substance situation, undoubtedly. And again, I think
To her, and you required her to be gone both before and after her own testimony because you said you might call her back in rebuttal. So she wasn't there to, be able to consult with counsel and things like that and support, the validity of the 2018 will.
two things I'd say that we did request her to be sequestered. That was not objected to. There was no pushback on that at all. So that was consented to. So I'd say, again, with that issue, that's...
And limine that said not to mention the fact that that's the only thing that they objected to.
Yeah, the the fact that she was a former party and also had to do with the brothers. But yeah, that was the only thing that was objected to. The sequestration was consented to, and that's why the court entered it. I do want to point out there was discussion about joinder. Deb was joined in this case. That's indisputable. Her rights were adjudicated, and importantly, they were adjudicated with her consent. I think a couple of cases that stick out to me is Swanson, which is 31 Northwest 2nd, 385. In that case, the court expressly permitted parties in a probate proceeding to enter into an agreement as between themselves. That resulted in a dismissal. I also want to point to the Butler case, which is 114 Northwest 2nd, 595, again in a state proceeding where the court accepted or adjudicated via a consent judgment. That's exactly what we have in this case. So I don't think the suggestion that there are no cases that inform the decision today is accurate. There was a discussion about partial validity. That was never raised. I don't know that it came up a lot in our brief. Certainly be happy, but it won't be difficult for the court to find the legal authority. You don't get to raise a partial validity claim after or even during a trial. That has
Outstanding. If we agree with you and reverse the new trial, are there still some motions outstanding for the district court to address?
one being the motion for a partial validity. And that's why I say I don't know that it ended up in our brief, but certainly in the district court, our resistance to that, we point out you can't raise it now. And I know that was one of the things the court struggled with in its ruling that we're here about today, indicating it felt awkward because it was adjudicating this idea of partial validity and she wasn't before the court. Well, candidly, Cheryl doesn't get to raise a partial validity after she's lost a jury trial. And the legal authority on that is very clear. The final thing I'll say, unless there's any additional questions, I want to reiterate the judicial processes for concluding, bringing an end to litigation between parties. It's not for imagining new conflicts between the parties after years, multiple trials, and jury verdicts. Thank you very much.
Of Janssen versus Security National Bank and executor is hereby submitted. We are going to take a brief recess here while the next case prepares for the third oral argument of the morning.